Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. Today we'll provide another installation into our Anti-Federalist Papers series going on to number 71. So if you haven't gone back and watched 1 through 70, I would highly encourage you to do so because understanding the Anti-Federalist Papers, in addition to the Federalist Papers, will equip you with a very well-rounded understanding of the U.S. Constitution, and understanding the U.S. Constitution will be absolutely necessary if you intend to combat any sort of lawfare waged against you, your loved ones, or your hard-earned property. So let's go ahead and jump on over to the Anti-Federalist Papers. The version I'm using is provided by the Constitutionalist Society, but there are multiple institutions from which you can get a paper and digital copy of the Anti-Federalist Papers. Go ahead and get both. While you're out there looking, if you haven't done so already, go ahead and get a copy of the Federalist Papers so you can join us in comparing the arguments for and against ratifying the U.S. Constitution. Excellent. So number 71 is titled The Presidential Term of Office. Part 1 is from Luther Martin, The Genuine Information. Part 2, an excerpt from the 18th letter of Agrippa, appearing in the Massachusetts Gazette on February 5th, 1788. And Part 3 from By a Customer in the Maine Cumberland Gazette, March 13th, 1788. So Part 1 starts with this. The second article relates to the executive, his mode of election, his powers, and the length of time he should continue in office. On this subject, there was a great diversity of sentiment at the Philadelphia Constitutional Convention. Many of the members were desirous that the president should be elected for 7 years and not to be eligible a second time. Others proposed that he should not be absolutely ineligible, but that he should not be capable of being chosen a second time until the expiration of a certain number of years. The supporters of the above proposition went upon the idea that the best security for liberty was a limited duration and a rotation of office in the chief executive department. There was a party who attempted to have the president appointed during good behavior without any limitation as to time, and not being able to succeed in that attempt, they then endeavored to have him re-eligible without any restraint. It was objected that the choice of a president to continue in office during good behavior would at once be rendering our system an elective monarchy, and that if the president was to be re-eligible without any interval of disqualification, it would amount nearly to the same thing, since from the powers that the president is to enjoy and the interests and influence with which they will be attended, he will be almost absolutely certain of being re-elected from time to time as long as he lives. As the propositions were reported by the Committee of the Whole House, the president was to be chosen for 7 years and not to be eligible at any time after. In the same manner, the proposition was agreed to in convention, and so it was reported by the Committee of Detail, although a variety of attempts were made to alter that part of the system by those who were of a contrary opinion, in which they repeatedly failed. But, sir, by never losing sight of their object and choosing a proper time for their purpose, they succeeded, at length, in obtaining the alteration, which was not made until within the last 12 days before the convention adjourned. Resolved, that the Constitution lately proposed for the United States be received only upon the following conditions. The President shall be chosen annually, and shall serve but 1 year, and shall be chosen successively from the different states, changing every year. Signed, Agrippa. So now here's part 2. I have one difficulty in my mind respecting our admirable Constitution, which I hope somebody will attempt to remove. Article 3, Section 1. The executive power shall be vested in a President of the United States of America. He shall hold his office during the term of 4 years. Here is no declaration that a new one shall be chosen at the expiration of that time. Congress may determine the time of choosing the electors and the day on which they shall give their votes. But suppose they should think it for the public good after the first election to appoint the first Tuesday of September in the year 2000 for the purpose of choosing the second president, and by law empower the Chief Justice of the Supreme Judicial Court to act as president until that time. However disagreeable it might be to the majority of the states, I do not see but that they are left without a remedy, provided 4 states should be satisfied with the measure. The president elected is not to receive any other emolument, yet the Chief Justice is not disqualified as a judge. Why did our worthy Chief Justice at Cambridge, the year past, in his address to the grand jury, call upon them to support, quote, that free and excellent Constitution which it has cost the blood of thousands of our friends and fellow citizens to establish? That Constitution which has carefully separated and distinguished the principal departments of power, that they might never combine against the liberty of the subject. If it is not a necessary article in a Constitution, if necessary in a state constitution, why not in one for the whole people? Was it not as easy to have said the president should be chosen every 4th year as to have said the representatives shall be chosen every 2nd year? The celebrated Mr. King observes that this is not a confederation of states, for the style is in the name of the people. Therefore, it appears to me the rights of the people should be as well guarded on this point here as in the constitution of a state. Signed, a customer. So I guess that was part 3. Anyway, if you have any questions about what was said in number 70, maybe questions about what was said in the preceding papers, or if there's a legal topic you'd like me to cover in a future lecture, go ahead and post those down in the comments, because the entire purpose of the Calhoun School of Law is to provide you with the necessary skills and information to combat any sort of lawfare that will be waged against you, your loved ones, or your hard-earned property. So please, if you have any questions at all, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope y'all have a wonderful day, and until I see y'all in the next lecture for the next topic, I bid you all farewell.